Well, welcome to the U.S. District Court for the District of Nebraska. I'm Judge Laurie Smith Camp, and we are in the security section of the court at the west entrance. If you need to come into the federal court to make a paper filing, which you do not need to do if you're a lawyer because you'll do your filings electronically, but some pro se litigants, people who want to file for bankruptcy and don't yet have a lawyer, may come in these doors, and when they do, they will see court security officers such as Roger and Eric, who are here manning the front gate. And after they go through the checkpoint, past our officers, they can make a sharp left, and they will see certain bins which had been used as paper recycling bins for purposes of paper shredding. These have been repurposed as drop boxes. So the pro se litigants will go up to the drop box. There is a desk where they can file stamp their documents to demonstrate the date on which the filing occurred, and then put the filing in the secure drop box. We promise those documents will not be shredded. They will indeed be retrieved by court staff twice a week here in Omaha, once a week down in Lincoln, and duly filed. We have what we refer to as a skeleton staff here at the courthouse. Most everyone is now telecommuting. So please be assured that your motions that you are filing electronically are indeed being read. The briefs that you are filing are being read, orders are being drafted, and they are being filed. We are not having jury trials at the moment for obvious reasons, so civil and criminal trials have been pushed off past April 30th, but it is very possible that that date will be extended further depending upon the status of the virus and the pandemic. We are not having in-court hearings in civil or criminal matters, although we are proceeding with hearings in telecommunication whenever possible. About a week ago, Congress passed a new law that is referred to as the CARES Act, an acronym referring to the coronavirus and the pandemic. And one of the things that the CARES Act permits is the federal district court judges to hold hearings by telecommunication and video conference in certain matters such as sentencings and pleas with the consent of the defendant and with the acknowledgement on the record that there is indeed a crisis that requires the proceeding to be held by teleconference. We've done several of those now in matters where defendants are looking at a sentence of time served because we want them to be able to get back to their homes and their families, and the space is also needed in the local jail facilities. Those have gone well. I have one more scheduled next week, and we're very grateful for our IT staff who have made that possible. Now, I may take you up to my chambers, which is very quiet and a little bit more comfortable, and we can continue the conversation there. I have 3 law clerks. They are telecommuting most all of the time. 2 of them have children at home, and so they have some responsibilities with their children and the homeschooling. We do see each other from time to time on video. We're not allowed to use Zoom within the court system, but we have other products that we can use, such as WebEx and Skype for Business and Jabber. So we do have access to communication. And then, of course, we're in constant communication through emails with orders that are being processed. So everyone is working. We are working remotely, we are working flexibly, but we are getting the work done. And it's the same with the clerk's office and with probation and pretrial. Obviously, people who are on supervised release or on pretrial release require supervision, and the probation officers are continuing to provide that supervision and to request warrants or transfers of jurisdiction as the needs arise. So it's not business as usual. As I mentioned, we aren't having the in-court hearings, we aren't having the jury trials. The grand jury has been suspended for the moment. We are having regular discussions among all of the judges and the constituent groups of the court, such as the Federal Public Defender's Office, the U.S. Attorney's Office, the Marshal Service, to make sure that we are aware of issues as they arise and we can handle them. So we do appreciate the patience of the lawyers and the legal community. Thank you for being patient with us. If your trial has been postponed, we recognize that that's a hardship for many of you, and we will do our very best to make sure that we work hard to catch up and that the litigants don't suffer unnecessarily as a result of this temporary situation. Right. We have been warned that with certain services, such as Zoom, there is a risk that people would be able to listen in on conversations or perhaps even join in on a conversation. That may happen from time to time. I have been doing yoga by Zoom, and that's not an official court function, however, and I don't worry too much if somebody breaks into the Zoom yoga and sees us in some, yoga posture and posts it online. I guess that might be embarrassing, but I can live with that. Whereas if someone breached a proceeding that was supposed to be confidential court business, then that is serious. So we try to make sure that we use the products that have the best security.
Absolutely.
We don't generally call it mediation when the magistrate judges do it, but it is a settlement conference. So the magistrate judges routinely engage in settlement conferences with the lawyers and the parties, and they do an excellent job. All three of them are very proficient at this. They've all had a lot of training and they've had a lot of success with those conferences. And of course, it's free to the parties if you use a magistrate judge for that. The district judges tend not to get involved directly with settlement conferences because we are the trial judges, and it may be difficult or even inappropriate for the lawyers and the parties to say things in front of us that they could say in front of a magistrate judge who is not going to be trying the case regarding the strengths and the weaknesses of the case. So yes, the magistrate judges do that, and they can do that remotely, as well as with people in conference. And they're very proficient with teleworking and holding hearings using their iPads or their Surface instruments. The district judges, at least speaking for myself, I am not as comfortable with that as the magistrate judges are, but with the help of IT, I can handle remote hearings, and we are being forced to learn that technology, which is a good thing. Right, I think that the whole concept of a jury trial, for example, is to have that personal interaction between the finders of fact and the witnesses and the lawyers. Very few of us would have pursued a career in law if we thought we were just going to be working on a computer screen. Many of us became lawyers, and some of us became judges, trial judges especially, because we love the personal interaction, working with clients and being in court with the interchange of human interaction. So it would not be as much fun, and it would not be as effective, and I don't think it would be in the interest of justice to conduct business exclusively by technology and at a distance. And I look forward to being able to get back into the courtroom and having that interaction. Well, that's hard to resist doing that. And of course, the last huge pandemic was the flu pandemic that occurred in 1918. And it's a little ironic that that occurred very shortly before the ratification of the 19th Amendment, and we are celebrating that this year. So I've been in communication with other people who are on the planning committee and speakers and panelists who are planning to come to Omaha the first week in August to participate in the 8th Circuit Conference and celebrate the centennial of the 19th Amendment and women's suffrage. And we have exchanged some interesting stories and talked about the irony of the pandemic situation. We are still optimistic that that conference will go forward. We had anticipated a record attendance for this conference. We were upgraded to the convention center across from the downtown Hilton. And we have decided to hold off on registration at the moment because people are concerned about other things right now, and they don't need to be worried about that registration. But we're going to look at that at the end of April, beginning of May, which would be the standard registration time for a conference of this nature. And we are all optimistic that we will be able to move forward. And we do have a fabulous agenda, so I truly hope for the sake of the Omaha community and the 8th Circuit and Nebraska that we will be able to proceed. Very much so. In 1882, Omaha was the focus of the women's rights movement and the suffrage movement. We were on the cusp of becoming, Nebraska was on the cusp of becoming the first state in the Union to have universal women's suffrage. There were a couple of territories, Wyoming and Utah, that did have women's suffrage, but we were poised to be the first state. And the legislation for a constitutional amendment in Nebraska made it through both houses of the legislature. This, of course, was before the unicameral. It was signed off on by the governor, and both women's suffrage organizations, the American Women's Suffrage Association and the National Women's Suffrage Association, scheduled their national conferences in Omaha back to back in September of 1882 to push this forward. And all the luminaries of the women's suffrage movement came to Omaha for those two conventions. And many people believe that because both the organizations came, it brought both those organizations together and helped them to find a common mission. They had split into two organizations after the Civil War in disagreement over the 15th Amendment and the fact that it provided for suffrage for African American males, but specifically did not provide for suffrage for females. So one good thing that came out of the conference, the two conferences, is those organizations did heal their wounds and come together with a common purpose. They also realized after Nebraska voters, who were all male voters, turned down the constitutional amendment, it did not approve women's suffrage, that a different strategy was needed. And instead of going state by state trying to promote women's suffrage, they said we needed a national amendment. And at that time, they focused on getting that amendment, which came to be the 19th Amendment, through Congress and ratified by the states. Well, I can pull my little Constitution, which has the list, and I do have it marked down. But it was 1920 that the final ratification occurred, and that was the state of Tennessee. And one of our keynote speakers, Elaine Weiss, wrote the book called The Woman's Hour, which is about the women's suffrage movement leading up to the ultimate ratification in Tennessee, which was a very dramatic moment where one man, influenced by his mother, switched his vote from nay to yay and put this over the top. So there was a lot of heroism involved in that very long battle, which of course began well before the Civil War and continued for more than 70 years. And it's something that we can celebrate in a time when it may be challenging to find things to celebrate. So whatever happens with the Eighth Circuit Conference, we will, I'm sure, have some kind of a celebration, but we're optimistic that we will be proceeding with the conference. Well, to put it in a little context, and also bringing in the current pandemic and those issues, the last big event that the Omaha Bar Association had was the medical legal dinner. And it was a lighthearted presentation. I don't think anyone knew that we were going to be hit with this pandemic. And at this moment, this is the hour of the doctors. They are the heroes. They are the ones who are getting us through this current crisis. And when that ends, which we anticipate it will in a month or so, it will be the hour of the lawyers and the rule of law. There will be people who are in desperate need of help, people who are losing their businesses, people who have lost their jobs. There will be contract issues for lawyers to sort out. There will be a lot of work for the lawyers. Some of it may pay well and some of it may not pay. But then the lawyers have the opportunity to be the heroes and the heroines and to get society back on course, to bring order out of chaos. And it is the rule of law that prevents people from going out into the streets and looting businesses, taking matters into their own hands. They know that they can go to the courts. They can go to a lawyer and seek help. And that under the law, they have the same rights as any other person in the United States. So with that assurance that the law is there and that we have equal rights and equal justice under the law, we will get society back on track where it was. But it takes the lawyers and all of the members of the Omaha Bar Association to take that mantle, and I'm confident that they will. I was interested in journalism, but I knew I was not fast enough to be a journalist who could earn a living. I was also interested in law because my father had been a lawyer, and he would take me along on his meetings with clients when I was very small. And I would listen to him counsel people about their estates and trusts and deal with issues that were very personal to some of these people. And many of them didn't have much money. Some of them may have run out of money, and he was counseling them about some of their options. I was impressed by his practice of law, and he also encouraged me and told me that he was confident that I could be a lawyer if I put my mind to it. So with that encouragement, I moved forward, and I have no regrets. Well, first, I'm very grateful to the Omaha Bar and the Omaha Bar Association for inviting me to serve this role. So thank you all for that. I'm thrilled. Part of the Omaha Bar Association culture is camaraderie and getting to know each other and developing that friendship and common purpose and making it fun to practice law. It's just a lot more enjoyable if you know the human beings involved in the process. And I want to thank you and the others who put together the pictorial directory, which is a fabulous contribution to the Omaha Bar and Omaha community. I have skimmed through it, and as someone who has what I believe is called prosopagania, I may pronounce it's incorrectly, but it's basically face blindness. If you have a bit of face blindness, and it comes in different degrees, it's so helpful to be able to have a directory like that and be able to study some of the faces and the names before a meeting coming up. And that's a wonderful thing to be doing during this downtime when some of us have to stay at home when we would otherwise be going out to movies or a restaurant. So I encourage the members of the Bar Association who are obtaining this wonderful product for free to skim through it and get to know each other, and then to attend the meetings when they are back on schedule. I've marked my calendar for September 10th for the kickoff that will be the barbecue, and that's a big highlight of the year. So hopefully by then I will have many more of those names and faces memorized. No, just thank you to the lawyers for their patience during this period of time, and for their optimism, and for then what they will be doing for the community to get us back on track in coming months.